Autumn's office was flooded, even worse than mine.
Matt's was worse than.
Matt's was worst of all. He deserved it. I mean, his was worst of all. At any rate, this is an operating while intoxicated second offense. The defendant entered a plea. This was bad facts. All the drunk driving cases today are bad facts. He's driving as a postal delivery carrier, drinking vodka out of the bottle, and just a bad circumstance. We have considered him for placement in the Sobriety Court program. Say we're taking somebody out of the drowning water and pulling them into the boat. Somebody needs to pull you into the boat. Mr. George, what would you like me to know?
Thank you, Your Honor. Well, I think the court hit the nail on the head. There's nothing about the facts of this case that are good. This was a nightmare situation, but I think that my client is trying to see this as a bit of a silver lining for him. As Autumn detailed, there was an incident that happened towards the end of 2024 and 2025. That was another operating while intoxicated case. There wasn't really much that came out of that. My client continues on doing what he was doing, and fortunately, he didn't hurt or kill anyone or himself, and he's here to talk to the court. But I think that the level of addiction that he's dealing with can only be adequately addressed through your Sobriety Court program. I think he's eager to get that treatment. He went and did a lot of this on his own, calling Pivotal, getting a substance abuse assessment, getting the other required assessments from Autumn. So I think he's on board and he understands. We've had conversations like this before. There's trying to do what you can to get the sentence that you're looking for, but Mr. Greenwald understands that this is really his life. He's got to make a decision on what his life looks like going forward. And I think that he needs to have the tools that this Sobriety Court can offer in order to adequately address any stressors, any life issues, and just the core of the addiction going forward. So, Your Honor, we'd ask the court to adopt the recommendation. I think it's appropriate and fair. My hope is that he really jumps headfirst into this and engages in the services and takes advantage of them, so that we don't have this type of situation going forward again. Thank you.
Autumn, we'll hear from you first, and then we'll ask Abigail if she has any additional input. You and I discussed this case. We've discussed it at Sobriety Court staffing. Bad circumstance, as Mr. George indicated. I couldn't find a driving record in here in the file, and I didn't realize it until this. Oh, there it is. It was the other one. He had that case in Kalamazoo County that was apparently just a probation. I'm not sure what happened in Kalamazoo County, but the violation was October 29th and of 24. And then our incident was October 12th of 2025. But apparently not much happened on a first offense drinking driving in Kalamazoo County.
Just to find some folks.
Which isn't unusual. Anyway, you've met with Mr. Greenwald. What's your recommendation here?
He does need Sobriety Court. He needs a serious intervention. Obviously, we're looking at just over the 1 year mark. We've got our second OWI, which is even more concerning is the fact that he was working and thought it was okay to consume alcohol. That's what's even scarier. So we discussed it. I expressed to him in length what it would be required of him of Sobriety Court. He assures me that he'll be able to complete it, that he states that he wants it. As Attorney George already pointed out, he has already completed the assessment with Pivotal. He's already started treatment with them. He is also in peer support with Betsy, which is phenomenal. He has been attending a 12-step meeting. It was online, but nothing in person yet. He is fully aware that those need to be in person. And as far as I'm concerned, we can get him started in the program tomorrow.
All right. Mr. Greenwald, to some extent, this is a blessing. We don't have enough of the resource to go around. We're about to graduate somebody and tomorrow, and you're about to take their spot. But obviously, I don't need to tell you that this was bad and you know things were bad and you need things to get better. Anything else you want to tell me?
I mean, up until the last couple of years, I mean, I was a good citizen. I mean, I was a good member of my community. I was helping coach young kids, and I need to get back to that place.
Well, that you describe the people in my program. Everybody in there has at least 2 drunk drivings, and at the core of it, they're all good people with a serious alcohol addiction. But you were driving as a postal delivery carrier with a .273. And that, I say this a lot, makes the hair stand up on the back of my neck. I could just give you a bunch of jail time, but that wouldn't get at what we're trying to get at. So I'm gonna put you in the sobriety court treatment program and consider this to be a gift. I'm gonna order 180 day, 24-month probation, 180-day jail sentence, credit 1, and 179 days to do. Of the 179, 185, 175 are deferred. You got 2 weekends to do, which will be scheduled by the probation department. Fine is 0. There's enough other stuff to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney fee, $960 probation oversight fee. Was there a police reimbursement in
Yes,
here?
2.
Oh, there it is. I see it. Thank you. And there's cost to be in sobriety court. Let's add what we've got up. You did pay a $500 bond, 125 plus 100 plus 150 plus 960 plus 200. They're coming in and out of that back door as part of the remediation from the flood. So that buzzer will probably keep going off. 1535. Sobriety court. I'm going to be in your business for the next year or so. As a condition of sobriety court, you're going to participate in 12-step recovery, AA in the rooms, or AA live, or other program like Celebrate Recovery or some of the other Life Ring or others. Most of our people are in AA and they're doing a good job. And the ones that remain successful remain in AA. You're going to do individual counseling and treatment. You've got peer support with Betsy, which is already encouraging. You're going to see me every 2 weeks. Tomorrow at 2:30, you're going to be here live and you'll meet everybody else. You're going to meet the guy that's graduating, who's done a lot of hard work in the last year. And then we'll get started. It gets easier as it goes on. Autumn, where do you want to meet with him?
I'll meet with him outside or in the hallway in the conference room.
All right. All right, Mr. Greenwald. I think we're going to be in a better place a year from now than we were at this time. And there's reasons why you were doing this. We're going to get at the reasons. All right. You have any questions?
I think, well,
All right. I'll see you tomorrow. There's a lot to do in sobriety court, especially at the first part. But your first session will be live. And after that, you can appear by Zoom. And will he be at Spencer's group tomorrow night too? All right, we're gonna hit the ground running. We're gonna get you in the program. All right, you're good to go.
Thank you, Your Honor.
thank you.
All right, Mr. Moore had to be 2 places at once. And rather than ask Cass County to, this is file number 252521, People versus Clayton Carr. Mr. Carr is present. He's charged with interfering with a crime report and domestic assault. He's here with his lawyer, Mr. Paul Gibson. He pled to those charges and the matter set for sentencing today. He has 1 day of jail credit. My notes indicate that the prosecutor did not object to a deferral in this case. Mr. Gibson, what would you like me to know?
Shortly after I believe the defendant was arrested, I was contacted by the defendant and I was also contacted by the alleged victim. The no contact bond was an inconvenience for the defendant. It required him to have to find a new place to live. And that's the kind of thing I think that kind of really sends a message to the defendant when something like this happens, that this is serious. This isn't just, this is real. This is a criminal case. This is serious business. And that's why those no contact orders exist. And so I think that the defendant in this case, it's my understanding he's got a full-time job. He's hoping to put this incident behind him. When something like this happens, I think people just wish that they could make it go away, but they can't just make it go away, and they have to deal with it, and it takes time. And so that's why it's taken us about a month to get to this point. But I think the defendant's learned a lesson here. I think that if he has an issue with alcohol, hopefully that he could get help for any alcohol problem. I don't think that alcohol helped in this situation. I think it contributed to both parties' conduct. And so I'm asking the court to consider fines and costs, community service, or probation as a sentence. Thank you.
Ms. Stoll, what's your thought here?
Thank you, Your Honor. I believe in this case, fines and costs are likely appropriate. My notes also reflect that he is getting the deferral. So this would be a good opportunity for him to sort of get his affairs in order and learn from his mistakes.
Well, that would be a good thing. All right, on the interfering with a crime report, I'm gonna order 1 day jail credit 1 day. I'm gonna do the probation and the domestic violence charge. That charge is gonna go on your record. That's not deferred. Mr. Carr, is there anything you'd like to tell me?
Yeah, I realized I made a mistake and I'm just trying to move past it, and I don't drink like that. That's not me at all. I was influenced by my significant other at the time, and I'm moving on from that, trying to better myself.
You say at the time, so you're not with Taylor Hall anymore?
We have no contact. I don't plan on trying to be back with her. I just want to put this in the past, and
But you don't have any children together?
no, we don't.
All right, well, they wanted me to lift the no contact provision as well, and they didn't provide any additional information. I'm gonna follow the recommendation for the deferral. I'm gonna do a 12-month deferral. I have to put you on probation to do the deferral. 11 days jail credit 1 of the 10 days ordered, of the 11 days ordered. 10 are deferred. There's a $125 fine, a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $480 probation oversight fee, and you're to pay for the class. Where are you working?
I work at a plastic factories in Sturgis. It's called Carter's Associates.
Let's add this up, 250 plus 150 plus 480, 880. I believe you posted $600 of bond. Again, it was a 10% bond. So 600 minus $60 is 540, leaves 340. You're gonna do the domestic violence anger management class. No drugs, no alcohol, test as directed, no assaultive or threatening behavior. The no contact provision is lifted. So if you want to talk to them, you can. But at this point, I guess you've moved on, and maybe that's for the best. Are you on probation or parole anywhere else?
No, sir.
Have you ever been previously convicted of any assault charge?
No, sir.
All right, again, our probation department's a bit disrupted with the flood. I'm gonna send you out with the court officer. I'll start on probation. Theoretically, you could be discharged from this probation at the end of 6 months if you successfully complete it. But the probation is up to a year if we need it. Or the court officer take you out to the counter. If you hold up your end of the deal, the domestic assault charge will be taken off your record and won't be a public record of that conviction.
Thank you.
All right. You're good.
Have a
to
great
go.
day.
All right, thank you.